As Alberta reopens, an increasing number of organizations are requiring people to sign liability waivers in light of the threat posed by the coronavirus, which raises the question, will an organization be able to rely on a liability waiver as a complete defense to a coronavirus-related claim?
Over the next several minutes, we will explain what a liability waiver is, what makes its terms enforceable, and what we expect Alberta's courts to do when the first coronavirus liability waiver is challenged. Simply put, a liability waiver is a contract that, when signed, results in the signatory giving up certain legal rights, including the right to sue, in exchange for an opportunity to participate in an activity, attend a location, or receive a service.
Like any contract, the enforceability of a liability waiver's terms depends on how they are drafted and the circumstances surrounding the waiver's execution. There are three primary considerations that Alberta courts make in determining the enforceability of a liability waiver's terms. The first is readability. Terms that are open to more than one interpretation, use excessive legalese, are unnecessarily long, and or are printed in unreasonably small font, are difficult to enforce, and may, in some cases, be interpreted against the organization that drafted them.
The second is distinguishability. Even the most readable terms may not be enforceable if the waiver does not begin by warning in large, colorful print that signing will impact the signatory's legal rights, including their right to sue. Similarly, terms that most significantly impact the signatory's legal rights are more likely to be enforced if they too are printed in a distinguishable way. For example, terms prohibiting the signatory from suing or obligating them to indemnify the organization that drafted the waiver.
The final and perhaps the most important consideration is the scope of the term that the organization wishes to rely on. Broadly drafted, seemingly all-encompassing terms will not be enforced unless they clearly apply to the circumstances underlying the claim that the organization wishes to defend. For example, a term that prohibits the signatory from suing the organization for negligence is unlikely to protect the organization if the signatory sues it for battery. It is best practice to actually list the activity's inherent risks and specifically exclude them. Organizations should also consider the time period and activities that the waiver is intended to cover.
So if an organization wants to limit liability related to the coronavirus, its waiver should, at the very least, begin by warning in large, colorful print that signing will impact the signatory's legal rights, including the right to sue.
Include a distinguishably printed term requiring the signatory to acknowledge and voluntarily assume the risk of contracting an illness, bacteria, infectious disease, and/or virus, including the coronavirus.
Include a distinguishably printed term requiring the signatory to release the organization from any and all liability arising out of or in any way connected to the contraction of an illness, bacteria, infectious disease, and/or virus, including the coronavirus.
Include a distinguishably printed term prohibiting the signatory from commencing any proceedings against the organization that are in any way related to the contraction of an illness, bacteria, infectious disease, and/or virus, including the coronavirus.
Ensure each term is succinct, uses as little legalese as possible, and are drafted such that they are only open to one interpretation.
And end by requiring the signatory to certify that they read and understand the terms of the waiver, that they understand signing it means giving up certain legal rights, including the right to sue, that they are at least 18 years of age, and that they are willingly and voluntarily agreeing to its terms. As I mentioned, the enforceability of a liability waiver's terms depends not only on how they are drafted, but also the circumstances surrounding the waiver's execution. To improve the enforceability of a coronavirus liability waiver's terms, organizations should
notify people ahead of time that they will be required to sign one,
explain the nature of the waiver in person before someone signs,
have a written instruction to read the waiver,
provide people with a reasonable amount of time to read the waiver and ask questions,
separate the waiver from other documents that need to be signed,
have the member of the organization who explains the nature of the waiver and fields questions sign the waiver as a witness,
provide signatories with a copy of the executed waiver,
and post a copy of the waivers on the organization's website and/or the organization's premises.
Additionally, organizations should not allow anyone to participate in an activity, attend a location, or receive a service if they were incapacitated or under duress when the waiver was signed. So, what do we expect Alberta's courts to do when the first coronavirus liability waiver is challenged? Assuming it was properly drafted and executed, we expect the enforceability of its terms to turn on two principles set up by the Supreme Court of Canada and Turcon Contractors Limited. The first principle is that unconscionable terms are unenforceable. Terms may be deemed unconscionable if the signatory was taken unfair advantage of, or if there was an inequality of bargaining power arising out of the signatory's ignorance, need, or distress.
The second principle is that terms are unenforceable if the very strong public interest in the enforcement of contracts is outweighed because the circumstances or conduct of the party trying to rely on the waiver was so egregious that public policy would say that the waiver should not be enforced.
One of the most talked about coronavirus liability waivers at this time is the one that was implemented by St. Francis Xavier University that, when signed, released the university from any and all liability in any way connected to the contraction of the coronavirus, even if it was negligent. Since the waiver was made public, many people have spoken out against it, as it basically meant the school could act unreasonably and negligently in failing to protect them against the spread of the coronavirus and still not be held liable.
If an Alberta university implements such a waiver and it was challenged, we expect its enforceability to turn on whether the court considers it unconscionable or against public policy. Students have argued that the lack of online classes forced them to choose between their education and their health. The school seemingly has unequal bargaining power in this scenario, as the students felt like they had no other option but to sign the waiver in order to go to school. Further, depending on what the school actually implements, a court might find it egregious and against public policy to ask students who are trying to pursue an education to sign a waiver absolving the university from liability, even if they are negligent in controlling the spread of the coronavirus.
British Columbia recently passed legislation that grants immunity to sporting organizations and entities providing essential services from coronavirus-related claims. They can, however, be held liable for gross negligence and/or failing to follow health officials' recommendations.
Similar legislation is being considered in Ontario, and we expect other Canadian provinces to follow suit. If Alberta implements similar legislation, then coronavirus liability waivers may be unnecessary for certain organizations.
So, will an organization be able to rely on a liability waiver as a complete defense to coronavirus-related claims?
Well, in our opinion, yes, provided that the waiver is properly drafted and executed and neither the principles set out in Tergon Contractors Limited apply. And remember, liability waivers are just one way organizations can protect against the threat posed by the coronavirus. A waiver on its own will not necessarily protect an organization. Liability exposure should be further mitigated by implementing and enforcing written policies and procedures, especially those recommended by health officials, aimed at reducing the spread of the coronavirus. We predict it will be important for organizations to show the court that they took reasonable and recommended steps to reduce the spread of the virus if a claim is brought. Thank you for joining us. We hope our commentary has been helpful and informative.
Please call or email if you want to discuss liability waivers further. We would be happy to hear from you.